If you are buying or building your first home, you may be eligible for the First Homeowner Grant. The First Homeowner Grant scheme is fully funded by the West Australian Government and administered by the Office of State Revenue. First homeowners purchasing or building a new home may be eligible to receive a grant up to $10,000. The First Homeowner Grant is not means tested, there is no income test, but if you or your partner have owned residential property before, you may not be eligible for the First Homeowner Grant. This video will cover certain key information about the First Homeowner Grant: how people can apply for the First Homeowner Grant, who is eligible for the First Homeowner Grant, cap amounts, residence requirements, legal implications, first homeowner rate of transfer duty, and where you can find further information. To learn more about the First Homeowner Grant, I spoke with Adrienne from the Office of State Revenue. How can people apply for the First Homeowner Grant?
People can get the application forms from an approved agent from the Office of State Revenue website. Banks and other lenders are what we refer to as approved agents, and there is a list of approved agents available on the Office of State Revenue website. People can apply for the First Homeowner Grant once a contract to purchase or build a home has been signed and dated by all parties to the contract and appropriately witnessed. If you're an owner builder, the application can be made after the foundations have been laid. An application for the First Homeowner Grant must be made within 12 months of completion of the eligible transaction and can be lodged through their bank or lender or with the Office of State Revenue.
Who is eligible for the First Homeowner Grant?
There is a comprehensive list of eligibility criteria available on the Office of State Revenue website that explains the specific conditions applicants must satisfy in order to qualify for the First Homeowner Grant.
Oh, okay. Can you give us a couple of examples?
Sure. To be eligible for the grant, applicants need to be a natural person, over 18 years of age, and at least one of the applicants must be an Australian citizen or permanent resident. However, if an applicant and or their partner owned a residential property or investment property anywhere in Australia before the 1st of July 2000, they are not eligible for the First Homeowner Grant.
What about after the 1st of July 2000?
Well, that depends on a few factors. They may be eligible for the grant, but it's best to carefully read the full list of eligibility criteria or contact the Office of State Revenue for more information.
Is there a cap amount on how much a property can be worth?
Yes, there is. If the property is located south of the 26th parallel of south latitude, the cap amount is $750,000. And if the property is located north of the 26th parallel of south latitude, the cap amount is $1 million.
Oh, okay. Is there anything else we should know?
Yes, it's very important to know that in order to be eligible for the First Homeowner Grant, each applicant must occupy the home as their principal place of residence for a continuous period of at least 6 months, commencing within 12 months of completion of the eligible transaction. An eligible transaction is a contract for the purchase of a home, a contract to build a home, or construction of a home as an owner builder that does not exceed the cap amount I mentioned earlier.
Okay. What does principal place of residence mean?
Principal place of residence is the place where you live. In certain circumstances, this can be a complex topic, and for more information, you should refer to Commissioner's Practice FOG 2.1, which is available on our website, and specifically outlines principal place of residence for the purposes of the First Homeowner Grant. If you are unable to satisfy the residence requirement, you must notify the Commissioner of State Revenue in writing. For more information, people can refer to the First Homeowner Grant fact sheet.
So say I'm a first home buyer and I'm not sure if I'm eligible for the First Homeowner Grant. Can I just lodge an application and see what response I get back?
No, it's really important to note that the application form, once submitted, is a legal document, and it is actually an offence under the FOG Act 2000 to provide false or misleading information. If you're found doing so, you could be prosecuted or face a court-imposed fine of up to $20,000.
Okay, so it's important that I check first whether I'm eligible before applying.
Yeah, that's right.
When purchasing a home and/or land, the buyer is liable for transfer duty. Transfer duty may be described as a general revenue tax which is imposed under the Duties Act 2008 on various dutiable transactions, including transfers of real estate. When a home buyer qualifies or would qualify for the first homeowner grant, a concessional rate of transfer duty may apply if the unencumbered value of the dutiable property does not exceed certain thresholds. As of the 3rd of July 2014, the first homeowner rate of duty applies to a dutiable transaction with an unencumbered value of up to $530,000 for a home or $400,000 for vacant land. If the property includes a home, as of the 3rd of July 2014, and the dutiable value of the home is $430,000 or less, there is no duty payable. If the dutiable value is between $430,001 and $530,000, duty is charged at a concessional rate for first home buyers. For vacant land with a dutiable value of $300,000 or less, no duty is payable. If the dutiable value is between $300,001 and $400,000, duty is charged at a concessional rate for first home buyers. So if you're buying or building your first home and you think you may be eligible for the first homeowner grant, you can access further information at www.finance.wa.gov.au or call the First Homeowner Grant Inquiry Line on 08 9262 1299. Thanks for watching. See you next time.